Negative and positive rights are rights that oblige either action or inaction. These obligations may be of either a legal or moral character. The notion of positive and negative rights may also be applied to liberty rights. To take an example involving two parties in a court of law, Adrian has a negative right to X against Clay if and only if Clay is prohibited from acting upon Adrian in some way regarding X. In contrast, Adrian has a positive right to X against Clay if and only if Clay is obliged to act upon Adrian in some way regarding X. A case in point: if Adrian has a negative right to life against Clay, then Clay is required to refrain from killing Adrian, while if Adrian has a positive right to life against Clay, then Clay is required to act as necessary to preserve the life of Adrian. Rights considered negative rights may include civil and political rights such as freedom of speech, life, private property, freedom from violent crime, freedom of religion, habeas corpus, a fair trial, and freedom from slavery. Rights considered positive rights, as initially proposed in 1979 by the Czech jurist Karel Vasak, may include other civil and political rights such as police protection of person and property and the right to counsel, as well as economic, social and cultural rights such as food, housing, public education, employment, national security, military, health care, social security, internet access, and a minimum standard of living. In the Three Generations account of human rights, negative rights are often associated with the first generation of rights, while positive rights are associated with the second and third generations. Some philosophers disagree that the negative-positive rights distinction is useful or valid.